How do I keep my son-in-law from getting my money? I'm Michael Redden, and that's the topic we're going to talk about today. It's usually pretty important to people that their legacy when they pass it on doesn't end up getting lost in divorce, and most of us have that family member really don't want to get our money. If you want to have any questions about this answer or have any comments, please leave them in the comments below. If you would like to plan with me, then go to reddenlawoffice.com and click on schedule a meeting. If you just like to have more information about asset protection in general, go to book.reddenlawoffice.com, fill out your information, and I'll send you out a copy of my book. So, this is very important to people. You know, a lot of us really want our money and things to stay in our bloodline to then go on to our grandchildren and things if something happens. Now, this isn't just divorce. Sometimes, we have to face that possibility that our loved one might pass away before their spouse. And we don't want that money then to go to the new spouse or be spent by them or go down their family lines. And the only way we can really do that is with a trust. If you write a trust properly, money will go inside of it. It'll benefit just your bloodline or just their family units. And it won't have that risk that it'll go out to a different person that you didn't want or that divorce will take it. We always hope that if we give people money, they'll do the right things, they'll keep it separate, and it won't be a divorce issue, right? But divorce court, that's family court. That's a court of equity. That's feelings. If you really want to have that protection, you put it inside a trust. And in Minnesota, if you put that spendthrift clause saying my creditors and people can't get to it, it's protected. And we did not adopt the Uniform Trust Code provisions that allow them to be invaded for divorce. So divorce won't be able to get inside that trust if you put it there for your children. Now, what the money comes out from there with, that's where you've really got to do a lot of your thinking. Because if your child just takes that money out and puts it into the house, puts it into the family bank account, does those other things, someone else might get it. And the divorce court will absolutely spread those things out and take them apart. If they go buy toys with it, they'll be split out. Maybe the trust should buy the toy. If the trust buys the house, it's not in. If the trust has the property, it's not in the family's marital estate. It's not in that divorce estate. It can't be split up. But you can't really control what they're going to do with the money after they get it. Creditors can get at it when it goes into their hands, so can the spouse. So make sure that the money stays in there. Make sure the trust is paying their bills directly. If they need to have a bill paid, if they want a house, they want a toy bought, make sure the trust buys it. Make it really difficult for the beneficiary to just take that money out. When they take the money out, it loses those protections, and that's when those bad things happen. So, if you want to keep it away from your son-in-law, keep it in your bloodline, put it in a trust, have a spendthrift clause, and do as much as you can to make sure that the money doesn't come out and go into your beneficiary's hands. Make the trust buy those things. That way, even if your heir dies, the money doesn't then go over to their spouse. If you give it directly to them and they pass away, they're probably going to give it to that son-in-law to take care of the kids. And that son-in-law remarries. It's going to be going based on his new will. What if they have more new children and things like that? We want to avoid those things. That's really what a trust is about. So if you're worried about those kinds of things, make a trust. If you'd like to talk to me about it more, leave a comment in the comment section or go to reddenlawoffice.com, click on schedule a meeting.